Well, happy sip day, gentlemen.
What's going
What's
on,
up?
guys? Happy Sip Day.
Yeah, the topic we wanted to sip on today was basically on revocable trust, titling assets into the trust and why it's important. So, Tucker, I would like you to just give us an explanation of what a revocable trust is.
Yeah, sure. So there's two main types of trusts, revocable and irrevocable trust. The one we're focusing on today, like Nav said, is revocable trust. So essentially a trust is an account where you can basically title assets, put your assets, you know, whatever you need to do with your assets, you can put them into the revocable trust. And it essentially puts it into a box that has a plan, I guess you could say. And the box is essentially, you still have access to the box. There's no lid on the box. You can, if you put your car in there, if you put your house, if you put different accounts, things like that, you still have access to them. But essentially, what it does is it creates an estate plan. By when you pass away, the assets then have a plan of where they're going to go. So if you put things in a trust, throughout your life in a revocable trust, you can still have access to those items, access to those accounts. The difference with the irrevocable trust is once you put those into the box, the lid closes. You can't use it anymore. And they have their own, each have their own benefits. But today we're going to talk about a revocable trust. So um, I would say, do you guys think that explains it pretty well?
Yeah, I like the box. I'm going to stick with the box analogy
All
to
right.
go through that. So let me draw our box. So if our box looks like this, if this is our trust, if this is the Dunn family trust, right? We just got this call last week, right? A client sets up the Dunn, we'll call it the Dunn family trust. We'll pick on Tucker for this. Says, okay, I just created this trust with the lawyer. Now I got to move everything into the trust. So what we'll do is we'll retitle assets inside of the trust. So this could be, like Tucker said, investment account, house, business interests. Like these are common assets that we see retitled to the trust. But you still need a will. And what the purpose of the will is for is anything that you missed. So anything that didn't get put into that trust during your lifetime. The will is going to be what's called a pour over will. So anything that was essentially not included, I would say the most common ones we see for this are like a car, and then bank accounts. So your will still says, hey, if I didn't retitle the asset to my trust during my life, take all of this stuff and pour it over into the will so it makes it into the trust. And then, like Tucker said, the trust would specify like who gets what, when, and how out of the trust. And one of the advantages of this is um, trust will avoid the probate process. So anything that you missed, anything over here, that's going to be subject to probate, right? So that probate's a courts or a county court supervised process to make sure the proper heirs are getting the proper stuff. So anything over here is going to end up in probate. Anything that you took during your lifetime and moved it into the trust is going to avoid probate. So that's the primary reason we see these trusts created is probate avoidance or minimization. And
Right.
the second part of that is trusts don't die, people die. So in the event, and we're picking on the Dunns for this case, so we're saying this is Dunn family estate plan, Tucker and his wife. So if Tucker becomes incapacitated and Tucker can't manage these accounts, if they're in the trust, we already have what's called a trustee to manage the assets in the trust. So this is most commonly used, I think, kind of when mom or grandma becomes frail and needs help managing financial affairs. That's the most common use case we see for their life. But it could be any of us today, right? Any of us could suffer a disability or death sudden, or excuse me, disability or incapacity suddenly, and then need somebody to manage our affairs. So having that trust already set up and having the assets retitled in the trust, you've already named the trustee of who's going to step in there. I mentioned before the will is kind of that court supervised process. If you have no will or no estate plan at all, the court's going to write one up for you. And if I told Nav, I said, Nav, I need you to name somebody to be your trustee if you can't act. Nav and his wife would probably have to like talk about it, who the right person is. But Nav and his wife would definitely be able to say, ooh, it shouldn't be that person.
Right.
And by creating a will and a trust, you're essentially naming those people. So you're excluding the people that you're like, hey, I'm not quite sure if it should be my brother or your sister at that top thing, but you probably would be okay with either. But you definitely don't want it to be this, third person that you're thinking of. So creating that lineup does help both for the incapacity and then, like Tucker mentioned, ultimate death to make sure it's getting where it's going.
So Joe, I think there might be a confusion with for some people about, I thought I did a will. I thought all of my assets were, you know, basically told where to go. If someone did a will and not a trust, are they still okay?
Yeah, the example that I use for that is it's ultimately going to get the same place. So if we were going to drive to New York City from DC, we could take 95 or we could take Route 1. And both of them are going to get us there, but Route 1, we're going to hit some stoplights along the way. So if you're using a will, you're going to go through the probate process, which is going to kind of cause you to hit the stoplights, which will slow things down. Probate, we definitely see to be like a 6 to 12 month process. Could be longer depending on the complexity, but it's ultimately going to get where you want it to go. So there are some circumstances where a will makes sense and not a revocable trust. But the revocable trust is essentially 95 in my example of it's already in the trust. It's outside, passes outside of probate. You've already specified who controls it and where it goes. And the people die, but the trusts themselves don't die.
Gotcha.
One area that I left out on there was bank accounts. And this was actually the conversation I was in because the lawyers, I think, correctly made the correct legal advice. So no one on this call is an attorney. But when we have a joint bank account, like my wife and I have joint bank accounts, I have elected not to move my joint bank account into my revocable trust. I'm making an intentional decision to do that. When me or my wife dies, the other one, or for being incapacitated for that matter, the other one can manage that bank account. It's really then at the second death that it becomes more important to put it into the trust. So two things can be true at once. The attorneys can make the corrected recommendation to say, hey, take all of your assets, put in the trust, but I've kind of looked at it in a practical matter of, you know what, I don't really want to write a check for my checkbook to my kid's T-ball that's like out of my trust account. I
Right.
just think that might be like perceived a little strange or the optics of that are a little odd to kind of live day to day. So I've elected not to put my checking account in the trust. Uh, Arguably, we both could die in some common accident, in which case my bank account would be, like Tucker's point, it would have to go to my will and then would get poured over into the trust. So it would hit a stoplight. It would slow some things down. That's a trade-off that I'm comfortable making in consultation with my attorney, in conversation with my wife on how we think about it.
Yeah, it's a really good point. And the graphic that you drew with the trust and the assets that went into the trust, those are typical assets that you can't name a beneficiary on
Mhm.
directly, right? So a business, house, bank accounts, you can add TOD or POD. So that helps with the probate process because it tells it directly where this account's supposed to go. But some assets you can't. So those are a lot of reasons why a client would use a trust is they want to dictate and say, hey, this is my business, my house. I want it to go a specific way. The court doesn't have to be involved because it's already specified in the trust. Um, Versus the will, you can say it within the will, but and even if you build a will within the trust, like Tucker brought up, it still has to first go through probate because it wasn't titled in the name of a trust. It's still in your name, and then it flows through your will, your testamentary trust through the will. So great topic, great questions. Um, and I really like the idea of it's not a one size fit all for everybody. Some clients, a will is more than enough. Other clients, it might make sense to do a revocable trust. Other clients, it might make sense to do a revocable trust for all three. So contact us if you have questions. We'd love to talk about your specific situation and see which one makes the most sense for you.
Perfect. Thanks, Nat. Thanks, Tucker.
Thanks,
Thanks,
gentlemen.
guys.